Omar Madison. And where is Omar in custody?
He's in custody, Judge. That's one of the things I got to talk about. Last time we were here, when he left, he said, you called me back up, you showed me that the bondsman had filed paperwork on it.
Yes.
I talked to Omar on the way out. He went straight over there and talked to him. I don't know if they didn't reach an accord or what. So
They didn't.
I need to get a bond set on him also.
All right. Have you spoken with the state on the bond?
No, but I need to get a bond set on him.
This is the case where the bondsman, I do remember the bondsman going off of this case. We had just had a setting and then he left and I called him back and his client had already left and signed the reset form. And I let him know that the bondsman was asking me to let off his bond. And you contacted the bondsman and the bondsman seemed as though.
I got hold of Omar in the hall. He went straight up there and talked to him. And did they tell you they're going to stay on the bond? Yeah, he did. I guess that's not how money is. Okay, it's money deal, Judge.
All right. I don't know if you want to call the bondsman or if you all want to talk about setting the bond.
I guess let's set a bond first. And I'll call them and see if they'll get back on it.
So what was the previous bond?
Do you know what your bond was? He thinks 15,000.
Oh, you know what? I actually have it in here. Yes, it was 15,000. So, State, I don't know if there's anything you want to agree on. I don't know. Is this family violence or it's all right?
We'll agree to it.
Setting it back at 15,000. Caroline, can you turn off the B page for me?
All right.
And I'm assuming there'll be there's be no contact with the complainant.
That's not even an issue yet, Judge. Is that a state hospital? So. And Your Honor, regarding our setting, the state's still looking into a couple of issues with some of their evidence. And I think that Marcus needs a little bit more time to look into that.
That's fair, Judge.
What evidence?
Contacting with this is one, and there's another one today, just to get recorded of that. I was supposed to look into something and I haven't had a chance to do it yet. This one specifically contacting the witnesses who work at the hospital.
Oh. And of course, I don't take any of this to be true, Mr. Madison, because I don't have any facts in the case. But is this something that's alleged to have happened at the state hospital?
Yes.
And is he alleged to be a worker at the state hospital or something else?
He was.
At the time, right? And there's one of the issues, Judge, is there's no witnesses to anything. It's a hypothesis case, a circumstantial case at best.
All right, so is he employed?
He's no longer employed at the state hospital.
And is he employed as a home health care provider anyway?
No.
All right, so just for me, I'm gonna put in here that there's to be no employment as a home health care provider. And of course, depending on what happens with this case, you know, things may be changed.
That's not a problem. He's working in the food industry.
Oh, okay. Okay, that's when it will be set. And if you just give that to the clerk, we have one clerk, so they'll put it in the system today.
Thank you.
All right, now, so with regards to this information that's needed, State, when do you think you'll have your information?
Judge, I'm not sure. However much time you're willing to give me, I'll try to make it happen before then.
All right, do you know at, when I was a student attorney at St. Mary's, they always tell us, hey, when you go out to investigate or whatever, go in Paris. And the first assignment we had, because I wanted to do criminal law, other people wanted to do civil, so it was a civil issue. And the first case we had was to go to the state hospital. And I don't know if things have changed, but we went to the state hospital. I'm thinking of all the movies that I watched in the past. And I'm like, do we get a badge or something? No badge, doors closed behind you. I'm like, how do they know that we're not supposed to stay here? But obviously I'm here, so they let us go.
Had the same experience.
Yeah. Norma, on Mr. Madison, can I have a 30-day reset, please? All right, we'll be back on July 25th. In defense, do you have all the discovery?
I believe so, Your Honor. Some new videos came out, but I think I have all of them. I'll double check on that.
All right, so on the 25th, I'm going to want an acknowledgement of discovery done as well.
Yes, Judge.
All right, thank you.
Thank
I'll
you.
just get a reset form from Ms. Ferguson, and then that will be placed in the system today. And Mr. Robertson, you may want to call the bondsman, because sometimes when they file paperwork, it's lost in the system and it's not to me yet. So before you leave, you may want to call them and see if they're back on the bond, because if they are, then the deputies won't have to escort him.
I don't think that, for what it's worth, a lot of those affidavits that said we contacted our client's attorney. They,
See, I'm gonna start having hearings on that. But when people do the affidavit, I'm expecting that they're speaking the truth.
Right. Maybe 1 out of 20 calls.
Oh. All right, Caroline. Who's here on Petra Calderon? And where is Petra Calderon?
She's gonna live there.
All right, if you could have her come up, please. And what is happening with Petra Calderon? Yes, what's happening?
Marcos, there's about 5 cases. Marcos wants to look at all those and give me an offer on all the cases. We had hoped to have done it this last month, but he was really busy and couldn't do it. So now he's told me that he
This
will,
is that other one, Judge, that I mentioned. He said there's one more.
he
Brandon,
will,
was he busy?
He was really busy.
he will try to give me the offer before court so I can go confer with my
I'm
client.
gonna put him under oath.
Yeah, well,
We know where he was. All right,
so we need a reset. If we could.
all right. So you need to make an offer. Will you be able to make an offer when? Do you think?
Within a couple weeks.
Okay, so what I'm gonna do, because she's in custody, I'm gonna call this. No action. Norma.
Yeah.
On Calderon, are you able to put that on the 25th as well? All right, so we're gonna come back on July 25th. That's when I will be back.
All right, we'll see if we can.
All right, just get a reset form from Miss Ferguson.
Okay.
And Miss Calderon, if everybody has something before then, your attorney will contact the court and we'll put it on the docket sooner, okay?
Yes, ma'am. Thank you.
You're welcome. Do you see what page Calderon is on?
Vince Sean Allen is supposed to be here. He was late. He's not my client. He just wanted me to let you know.
All right, thank you. I appreciate that.
Yes, it's page 10.
All right, thank you. Don't file that away because it comes back on. Carmelo Figueroa. And where's Carmelo Figueroa?
I think it's in the background.
Okay. All right, just as soon as the deputies bring them out, then we'll take that up. Isaiah Gonzalez. Isaiah Gonzalez. Who's the attorney for Isaiah Gonzalez? No, Eduardo needs to come out. Yeah, thanks. Damon Lloyd. All right, Mr. Lloyd, come up. Good morning. Was your client late this morning?
I think he was caught in that line wrap. Did you answer when I called you?
No, I was late.
All right, so why were you late?
I was stuck in a line outside, wrapping around the building.
Okay, all right. All right, what is happening with Mr. Lloyd?
Spoken with prosecutor on it. They're still trying to hold the complainant in the case, and also the process of putting together a mitigation packet on Mr. Lloyd.
All right, who's the prosecutor?
Mr. Groom.
Oh, and I understand you can't walk.
Yes, Judge.
So,
Judge, if we can, I believe he's gonna get me some stuff, and then we're gonna try to reach out to the victim again to try to figure out. I think it's just one where I want to talk to him before I decide how to proceed with the case.
all right. So I'm gonna set this one more time. This will be the last time, so the states to make an offer. And defense, do you have all the discovery?
I believe you do now. I'm going to double check. There was a video that appeared to be truncated that I got, but I don't know if it was a copying error, or if that's how they got it from the police, but I'll get with Mr.
All right, so on the next setting, I'm going to expect an offer from the state in acknowledgement of discovery. Norman, can I have a 30-day reset on Mr. Lloyd, please? All right, we'll see you back on July 25th. Ms. Ferguson will give you a reset form. After you sign that, your excuse.
Thank you.
All right, you're welcome. Who's here on Nathaniel Tristan? All right, where is Mr. Featherston? All right, thank you. All right, everyone, the court is taking a break at 11:50. So anyone who's not done, you're gonna have to come back this afternoon at 1:30. And who is on Carmelo Figueroa?
I'm present, Your Honor.
Yes, and he's
Mr.
out.
Figueroa is here.
All right, let's bring him up. All right, what is happening with Mr. Figueroa?
Your Honor, I had previously filed, I don't know if you can hear me.
Yes, I can.
Previously filed a motion for continuance the last, it was last week. It was brought over this week there, and my husband has been, he's undergoing eye surgery. He had it last week, he's gonna have it again, and I'm not able to be effective or be able to be present during trial for this, like for the 2 weeks.
All right, so the problem is that this is a tent setting case.
I understand, Your Honor, and I would love to try this case. I would rather be here than taking care of what I'm taking care of. But to give Mr. Figueroa the attention that he would require, is something that I feel like I cannot in good conscience say.
All right, we're gonna go on the record. Court is calling 2021 CR 8904 and 2021 CR 8903, State of Texas versus Carmelo Figueroa. Can I have parties announced for the record for the state? For the defense?
Catherine Valenzuela.
And are you Mr. Figueroa? All right, your attorney is asking for continuance. Do you have a copy of the motion for continuance?
I have not filed one for today's print, and we will, Your Honor.
Oh, just 1 second. Has one been filed? Can you check the system?
It has not been filed, Your Honor.
All right, well, the court can't have a hearing until a motion is filed. So that needs to be filed today. Otherwise, you all need to be back here at 1:30 for trial.
It will be filed today.
All right, and then we'll have to have a hearing on it.
All right.
All right, and here's the thing. I understand what everybody's going through, but this is a tent setting case. It's a jury trial. If people want a continuance, you have to file a motion for continuance. So, I mean,
I understand.
all right, thank you. Isaiah Gonzalez. Isaiah Gonzalez. All right, I think. Nathaniel Tristan.
Morning, Your Honor.
Good
Robert
morning.
Featherston and Adam Paulson here on Mr. Tristan, and he's present.
All right, Mr. Tristan, you need to come up.
It's the joys of getting older.
Your Honor, may I address the court?
Just 1 moment. Yes.
Okay, it's on page 8.
All right, thanks. You sure it's on page 8? It's my vision,
Yes.
because I don't see Nathaniel Tristan on page 8.
Oh, you're looking for Tristan.
Yes.
Okay, sorry.
I think it's the second page of the recall document.
Yeah, he's on the recall.
I was just
The-
like, oh my
the fourth
gosh.
one down.
All right. We're gonna go on the record in 2019 CR 8838, State of Texas versus Nathaniel Tristan. Could our parties announce for the record for the state,
Michael Villarreal for the state.
for the defense?
Robert Featherston and Adam Pauls representing Mr. Tristan.
All right, it's my understanding you have some motions.
Judge, we do. We have some pretrial motions, and there's also a continuance motion that I filed this morning. I have to be in federal court at 11 a.m. Mr. Paul is going to argue the pretrial motions. And I guess what I need to know is whether you want me to argue the continuance after I get back from federal court, or do that now?
So you can argue the motion for continuance now.
Okay.
So first off, for the record, the defense is arguing the motion for continuance. State, have you had a chance to review the motion for continuance?
I haven't, Judge.
Judge, the motion for continuance is,
Oh, the state hasn't had a chance to review it.
it's in the back.
Switch for me.
Yeah. Okay.
All right, do you want the court to make its ruling based upon your motion, or would you like to have argument, Mr. Ferguson?
Judge, all I can tell you is that Mr. Smith and Mr. Lozito finally released funds to allow the treatment court to travel to do this required training in the month of July. I'd have filed it earlier if I could, but we didn't have a line on funding. So
Are we not set
it
for trial today,
interferes.
though?
No, you're on. Except for,
Oh, we're set in July? Okay,
it's July 19th, Judge.
It should be listed in the motion.
all right, so with regards to your motion for continuance, Ms. Ferguson, because you're leaving on the 21st. Is that correct?
Yes, Your Honor.
All right, then Ms. Ferguson, is there a date before July 19th to set this?
Judge, and this is the one, I don't know if you recall, several settings back, we had set it for this date specifically because we had a issue concerning one of the state's witnesses' availability. We had probably two separate hearings on this motion, the prior motion for continuance on that. And so this was a settled date by both parties.
Is that correct, Mr. Ferguson?
That's correct, Your Honor. It is. But as the court knows, circumstances change as time goes on.
All right,
And this issue has come up.
all right, motion for continuance is denied. What other motions do you have?
Judge, I think we've got 11 other motions. They should take maybe 45 minutes. We've spoken with Mr. Villarreal. We've agreed on some issues, but not others.
All right, so what have you all agreed on?
Go ahead.
And just give me the motion that you're starting with.
Okay, certainly, Judge. On defendant's motion and limiting number 2, Judge, it's the lengthy one.
Yes.
We have agreed, and Michael, please feel free to correct me, under Roman numeral 1, Judge, general matters, we've agreed on A.
All right, and let me explain to you how this court does voir dire. how I do voir dire, there is not a strike for cause or any strikes that are done in front of the panel as a whole.
Yes,
What
Judge.
ends up happening is if there is some strikes that you all can agree on after voir dire has concluded, then the court usually accepts those agreements. And then whatever you cannot agree on, I'll make a ruling on that.
Okay.
But you all are agreed on A,
On A, Judge.
all right?
We're agreed on B as well.
And Brenda, we can be off the record for this.
Okay. And I may have to run downstairs.
Sure, no problem. All right, and C,
We're agreed, Judge.
D,
We're agreed.
E,
We are not agreed, Judge.
okay. State,
Are you in on E?
yes.
Judge, I don't think necessarily this is part of the facts here. And I have to.
So did the defendant give a statement or no?
Unfortunately, this is Michelle's case and I'm just here for motions.
Ah.
But
So
I
did-
don't believe he did.
Did he give a statement?
Judge, he did call the police. He did not, he called the police voluntarily on this one. But he didn't, it wasn't under interrogation. He wasn't brought down to the station or anything. It was a 911 call, Judge.
Okay. And is the 911 call considered a confession?
Your Honor, there are some discussion of the facts of the case in the 911 call. It's a statement that we don't consider to be a confession. And we're merely asking the court that if the state wants to call it a confession, that they approach the court and we'd be allowed to discuss that issue outside the presence of the jury.
All right, that'll be denied. And then on F,
Judge, I believe it.
We can agree on that.
okay. All right, so I rolling sign immature and unprofessional behavior, state to be promised not to do
Shockingly,
that.
we can agree. I know.
Speaking objections, I don't allow speaking objections from either side.
So is that one agreed, Your Honor? Or
Yes,
granted?
I don't know, I don't allow speaking objections. So everybody knows the rules.
Yes, Your Honor. C, we agreed upon, Judge. D, we agreed upon, Judge.
Okay, striking the defendant over the shoulder, striking at the defendant over the shoulder of counsel. Okay,
That one's agreed.
all right. Community expectations.
Under A, Judge, we're agreed.
Okay,
Under,
personal opinion. I don't think, yeah, you guys are agreed on that?
well, we're not agreed on A or B, Judge.
Okay, as far as
As far as A is concerned, it's just.
well, I mean, if the state is, are you saying if the state is having closing arguments, they can't say the defendant is guilty and here's why? I'm trying to figure out what does that mean?
I just want to make sure we're talking about the same one. Where my A says that he represents the members of the jury panel or the public. Is that the A we're talking about, Judge?
Oh, that, okay. As far as them representing the public, don't they represent the public?
Well, that they represent the members of the jury panel. I don't think we have any objection with them stating that they represent the state of Texas. But I don't want them to go through and say, juror number one, we represent, we're here because we represent you. Juror number
I've never
two.
seen the state do that. Are you planning on doing that?
I don't plan on doing that, Judge, but we do obviously say we represent the state of Texas. So that's kind of the issue with A.
All right, so I'm gonna write in here, exception. State, may state. It represents Texas. All right, and then the other thing will be agreed to.
Okay.
And what I'm gonna do is strike through where it says other or the public. Because you just don't want the state to say that they represent each juror member.
Correct.
Okay. So any problem with the court striking through the public part? Would you all initial that for me? Where I struck through? If you could initial it.
Of course, Judge.
Yes.
Do you want me to use my pen or
Oh,
yours?
yeah.
Okay.
Yeah, it's fine. Okay.
Do we have Michael initial
Yes.
as well? Okay. Here we go. sorry, I should give you the binder as well. Thank you, Judge.
All right, then we have the prosecutor believes that the defendant is guilty. Are you saying they're not allowed to say that at all, even in closing arguments, or?
Our objection would be that his personal belief is that the defendant was guilty. We believe that the argument should be limited to what the evidence would show. And if we have no objection to him saying that the evidence would show that the defendant is guilty, but his own personal belief that the defendant is guilty.
It's mincing it into the clear objection from the state is that we're gonna argue that he's guilty. Obviously, we're in trial, so, and I think it's too broad of a.
So I don't see if, I don't think it's objectionable for in closing argument for the state to say the defendant is guilty, we're asking you to find him guilty, and here's why, which is what the state usually does.
Okay, I mean, if he's saying that this is the reason why and that he's referencing the evidence, then I think that that would be fine. You know, I just think that if he gets up there and he says, you know, I believe that he is guilty and doesn't reference the evidence or anything, it's unsworn testimony.
All right, I'm just gonna say approach.
Okay.
All right, and just approach prior to, and I think, and I could be wrong, I try not to assume anything. I think this is probably maybe it's happened before, not with the prosecutors in here, where maybe a prosecutor gets up and says, I believe the defendant is guilty.
I understand that the case was cleared up personally.
See or agreed upon, Judge.
Prosecutor's not paid enough.
It's true, Judge, but.
Yeah, but you're not gonna be, yeah.
We're agreed on.
I'll tell other people.
Prosecutor does not introduce evidence, okay, unless he believes it's true.
I mean, we don't plan on doing it, but the always concern that I have with having these ruled upon beforehand is that if he's introducing that he himself doesn't believe, if that's the argument, well, I should be allowed to rebut that.
So what I'll do is I'll grant it, but of course, if the defense ends up opening the door to that, then that may change. So defense, if you try to say he's presenting evidence that he doesn't believe, then that may
Yes, Your
come
Honor.
back.
The next one we're not agreed on is G, Judge. We've
Well,
agreed
we're
on
on E.
E and F are both agreed.
Okay, E is agreed, F
Yes,
is agreed, G. All right, so is this relating to in general or relating to closing arguments?
I'm sorry, Judge.
All right, is this related to in general or to closing arguments?
I would say in general, Judge. I would say he's bolstering the witness's credibility at that point by
So you
stating.
mean while they're testifying, or do you not want them to mention that a witness, or they believe a witness told the truth because this is the evidence that supports that?
Right, Judge. I would say that they shouldn't reference the witness's credibility or honesty at all.
Even in argument?
And maybe in closing argument, but not throughout the trial, Judge. And I'm fine if they get up there during closing argument and they say, you heard from so-and-so who told you about this, and then the police investigated it, and this is what it showed. Because again, Judge, they're referencing the evidence at that point.
All right, the exception then will be closing argument. I've never seen the state say this witness is telling the truth after they
I think we've
testify.
asked questions of witnesses that said, if somebody were to testify as to this matter, would that be true?
So I'm just gonna have you guys approach on that one.
Okay.
I don't see where it would come up, but state just approach beforehand if that's something that's gonna happen. All right, H,
We're agreed, Judge.
I,
We're agreed.
J,
Agreed.
K,
Agreed.
all right. References to the defendant or complainant.
We are not agreed on A, Judge.
And there's a whole motion on that one, Judge.
There is.
All right,
Court light, we can circle back to that one when we have the other motion heard, Judge.
well, no, I want to hear it now.
So I spent a lot of time on this one, Judge. I'll tell you. I looked at every time that the word victim is mentioned in the penal code, and it's 145 times. If the word victim is mentioned 1,056 times in the Code of Criminal Procedure. It's particularly mentioned in chapter 22 for sexual assaults, a total, well, that's the whole assault chapter 25 times. In fact, the sexual assault statute mentions the word victim 3 different times when it speaks to affirmative defenses. I can go through other portions of the penal code and the Code of Criminal Procedure, but it's clear that the legislature uses this word, the proper word to use. It has a particular meaning within the vernacular of most of our jury members and venire members, whereas complainant, the alleged victim, these are all one and parcel the same. So,
No, and
think it's
I
improper.
understand the defense's argument, because the defense's argument is that a person is not a victim until a jury finds the defendant guilty. I understand your argument with that. All right, that'll be denied. All right, B. I'm sure you all are agreed on B.
Sorry, Judge, I'm going back to that
yeah,
page.
see,
Yes,
All right, and I think election of defendant not to testify, I'm sure that's agreed to. Is that correct?
as far as A is concerned,
A is not agreed, Judge.
I think we bring that up in for Dyer in particular, when talking about one witness rule, things like that. Remember, he has the right not to testify. We're talking in the context of the Fifth Amendment. And so I don't want to get into any trouble when we talk about the one witness rule and how much the state can put on.
All right, and what I can tell you is I always do voir dire as well. That's an introduction. And I always tell the jurors that the defendant has the right not to testify and you can't consider that.
Okay.
So,
And I guess our argument would just be that the state wouldn't get up there and say, you know, we can't call him because, you know, or we would love to call him, but we can't call him.
no, I don't.
I mean, we can say that we can't call him as a witness. That's a factual statement of the law, especially more dire.
All right. So, as far as it relates to voir dire, that'll be denied. Of course, during the trial, there can be no comment on his not testifying.
Okay.
So it'll be denied for voir dire. And I have put in there, denied for voir dire. So it's granted for everything else. Of course, if something happens, somebody opens the door to something, then say just approach beforehand. The motive for the offense has not been revealed or is locked up.
We're agreed to that one, Judge.
All right.
Well, okay.
The concern I have with this one again, Judge, is that we talk about in voir dire, we don't have to prove a motive. I understand they're seeing it from a different paradigm, but I'm seeing it from the paradigm is when we talk about the Fifth Amendment. We can talk about the laws related to the Fifth Amendment and the state's burden of proof and what it has to prove. And so motive is something we don't have to prove. And so we talk about those things.
All right, they just approach, and if there's anything outside of talking about in voir dire that the state does not have to prove motive, if you go beyond that, you're gonna need to approach.
Your Honor, may I address the court?
Yes,
Judge, I need to depart now to go to the federal court.
yes.
Adam will be handling it for this
All
one.
right, no problem. Thank you. Walk safely.
Bob, she said walk safely.
Oh, thank you.
All right, so I said that the state is allowed to address the jury panel concerning the issue of motive, not as an element of the offense.
It's fine, Your Honor.
All right, C, it has not been contested that the defendant committed the offense. What I can tell you is usually what state will do, and I'm just speaking in general, is they will say, nobody's contesting that it happened in Bexar County, whatever happened. Nobody's contesting this date. So is this for closing argument or is this for something else?
I would argue, Judge, that it incriminates his Fifth Amendment right to remain silent, as well as, I guess, just, again, it goes against his Fifth Amendment, Judge. And the fact that,
Doesn't speak to what the defendant is saying or not saying. So I think this is, within the scope and bounds of an argument.
and Judge, I think it shifts the burden. We have no duty or obligation to put on a case. And so it's not up to us, it's not up to the defense to show that he did or didn't.
And I'll tell you why it's hard for me to rule on these, because I've never seen the state do this.
Okay.
I know, obviously, somebody has done it in the past, otherwise you wouldn't have the case law. So the state, just approach on that, if that comes up. I don't see it coming up.
And so I know Michael's very seasoned. We're agreed on D.
Okay.
We're agreed on E.
And he is when we work very clearly on like what he's that particular, very particular
Yes.
reference.
All right, F.
We are not agreed on F, Judge.
What is the state asking rhetorical questions of defense counsel or the defendant? When would this happen?
You say, when would it happen?
Yes.
Just either in closing argument, Judge, or say, why wouldn't they put him up on the stand? Why wouldn't they call this person?
Okay, I don't see that happening, but I'm going to deny that. State, you know the rules of evidence.
Yes.
And, yeah. All right, G.
We are not agreed on G.
It's basically after.
It is, Judge.
All right, that'll be denied. Now refer to the defense's failure to raise any particular defense, followed by references in the first person to the manner in which the defense could have articulated. All right, that state approach on that, because I don't know what the argument is going to be and what the defense is going to say in closing argument.
Yeah.
And I'll need to know that before I can rule on that to see if there's some sort of rebuttal.
And Judge, I think this is in the context of like, sometimes we argue, this is not a case who done it, right? We're not arguing this particular element of offense. So that's the concern I always have with, again, these theoretical things. So we don't know what the evidence can show at trial.
Defendant has not apologized or expressed remorse. I'm assuming that will come if the defendant were found guilty.
I would say throughout the trial, or if, there was no evidence brought that he didn't show any remorse or any sort of, or if he wasn't apologetic to the police or make any statement, then I just don't want them referencing it, saying, well, you heard him talk to the police, you didn't hear any remorse or he wasn't apologetic for what happened.
And this is assuming a lot of things, Judge, right? That he doesn't testify. Right? And he took the stand, and if he testifies in punishment and he's not remorseful, we can argue that.
So I'll state your approach. Okay, and proper reasons to convict.
Judge, we're agreed on A,
Okay.
we're agreed on B, we're agreed on C,
Okay.
we're agreed on D, agreed on E, agreed on F.
All right, criticism of defense counsel.
We are agreed on A, as well as B, C, D, E, F, G, H, I. We are not agreed on J.
Defense counsel did not argue that the defendant was innocent.
Shifts the burden, Judge.
State.
And the concern that I have here, Judge, is when we talk after it's a rebuttal argument and he goes through and again, these are all these hypotheticals that are outside the scope of what I can think of, but I think it's potentially possible to argue that he's not arguing that he didn't commit this.
We'll just have you all approach on that one. All right, defense counsel intimidated the witnesses, the court or the prosecutor.
We're agreed on that one, Judge.
All right. References to defense counsel strategy, courtroom tactics, or ethics, as suggesting that the counsel is shrewd or tricky.
We will agree to ethics and suggesting that the counsel is shrewd or tricky. We don't anticipate arguing any of those things, but I think we can talk about strategy and courtroom tactics in the sense of, you didn't hear, You know, they argue that we didn't bring a witness. You know, they have the same subpoena powers that we do. Nobody heard from that one. The things I think are well within the bounds of proper argument.
All right, I'm gonna put on here approach on non-checked items. So the agreement is ethics. Are you agreed to that?
Yes,
Shrewd or tricky?
I will agree that to not argue that.
All right, courtroom tactics.
I think those are the two things that we have, the strategy and courtroom tactics kind of those are synonymous for me. And so that's where I think if we just, it's objection, if he wants to object during argument, we can approach the objection.
All right, so the state is gonna approach on any of the non-checked items. So I've checked off ethics, shrewd, and tricky.
That's fine, Your Honor.
All right, reference to defense counsel making objections during trial. Hopefully no one will be making.
Yeah. We're agreed on that one. Judge.
Okay,
Yeah, and we got it, and we're agreed on N as well.
okay. All right, courtroom proceedings.
We're agreed on A.
Mhm.
We're agreed on B.
Mhm.
We are not agreed on C.
Okay, the court's inclusion in the jury charge of defensive theory or less included defense does not mean that the court believes it.
I think that's a proper statement that the court is instructing you on the law. They're not telling you what the evidence shows or what the court believes, and that's inclusive of every part of the jury charge.
All right, just approach. Because I don't, well, let me go back on that one. I don't see, is somebody planning on arguing that if there's a lesser included offense that the state, are you planning on arguing that, hey, it's a lesser included offense, the judge put it in there, but she doesn't believe it?
No, I think it's the converse of that is what the concern with the state is, that she put this in there, she's instructing you on what the law is, she's not telling you what the facts are, she's not suggesting to you that that's what should be the verdict in this case.
And that is our concern, Judge.
All right, so say, then you're agreed. You're not gonna tell the jury that I put this in a charge and I don't believe it, even though I put it in there?
I think it's proper for us to argue, and I don't know if I'm just, it's a Tuesday, that's a Monday.
Yes.
I think it's, and correct me if I'm wrong, is that we can argue that you provided the law and that you're not saying that this is necessarily true or untrue. It says that your job is to give the law to them and that they're to follow the law. That doesn't mean necessarily that she believes it or disbelieves it.
Right, and we're fine with him saying that, you know, the judge has given you the law because that's what the jury charge is. We just don't want any reference made to saying, well, the judge believes this is true. I mean, otherwise she wouldn't have put it in there.
Okay, so then it sounds like y'all agreed to this because the defense is the state is gonna be arguing the law and the law comes from the court.
Right, and we're fine with them referencing the law.
All right, everyone, just approach on that.
Okay. D, we're agreed on, Judge.
Okay. E,
We are not agreed, Judge.
that the defendant could elect what the court of the jury says punishments.
I think you talked about this.
Yes, I
specific
did.
word item.
I did this in voir dire,
Okay.
so that will be denied. And what I can tell you is I tell the jury that according to the law in Texas, the defendant has to make an election for punishment. That doesn't mean that the defendant is saying that he's guilty. It's just that those are the rules. And then I asked jurors if anyone would hold it against him for electing, if he's going to the jury for punishment or the judge for punishment.
Okay.
So I cover that in voir dire.
Okay. And then the rest we're agreed on, Judge.
Okay, agreed. All right, that one's done. What's your next one?
It is defendant's motion eliminating concerning the state's use of the word victim, Judge, which I think you ruled on. We just have a separate motion for it.
Okay. We'll use that. Okay. Okay, I'm sorry.
No, it's okay. It's the defendant's motion eliminating regarding the state's use of the word victim.
All right, and the court has already ruled on that.
Right, Judge.
And I think we've gone through so many.
Yes, Judge.
What number was that on your other motion? Oh, all right, it was on 5. And it was denied.
Mhm.
All right, motion for discovery and inspection of evidence.
Yes, Your Honor. Michael, I don't think we conferred on this one. Is that right?
I believe we did.
No, I don't have a marked one here. What's agreed and what's not. Oh, I guess I do, yes.
All right, so,
Judge 1 through 13, we are agreed upon. Is that right?
So I have 1 through 6.
Okay.
We are agreed on.
okay,
Oh, you're right. There is 7.
all right, number 7. Y'all are not agreed on that?
So I think this is just very broad and any report, record, working papers, communication, audio tape, videotapes, or other record of a report or investigation of allegations of abuse of the complainant. If it's within the state's possession, we can turn it over, but there's items that I might not know that exist that I can't possibly turn over.
All right, so I'm gonna grant it and I'm gonna add in state's possession.
Okay.
Number 8,
We're agreed on, Judge.
9,
We're agreed.
10,
We are not agreed, Judge.
yes.
This is stuff that's outside the state's possession.
All right, I'm gonna put in state's possession. So I'll grant it, but if it's in state's possession.
Okay.
Number 11,
We are not agreed, Judge.
the name, address, telephone, of the person who made the reports, contact, tests, experience, or evaluations requested in the foregoing paragraph.
And it's the reason we're not agreed is just because of number 10.
All right, I'm gonna say in state's possession. Same thing with 12,
No, we agree.
We are agreed.
13,
We're agreed.
14,
We are not agreed.
all right. In state's possession,
Well, the problem is also Child Advocacy Center employees records. So we're talking about CAC records that are not discoverable under 3915 of the Code of Criminal Procedure.
but in state's possession should cover that, correct? Or do you have it in your possession?
Well, again, this is discoverable, not production though. Like if we had some child safe videos, we're not particularly going to turn those over, but we'll allow them for inspection.
And Judge, if I could, I understand, the child advocacy center videos. I think we're more concerned with employees' records of like discipline or misconduct, or if they, if they've had any issues. That's what we're more concerned with.
All right, this is what I'm putting. In state's possession and available under the rules of evidence and procedure.
Okay.
15,
We're not agreed, Judge.
And again, this is outside what could be in possession of the state.
all right, in state's possession. Name and address, that would be in state's possession. Prior criminal record of each state's witness, number 17.
17, it's just, we're asking for the TCIC and CIC that it be made discoverable but not production of those records.
So during the trial, you will give it to them for purposes of cross-examination.
I can provide them under Rule 412, really, Judge. But I can't physically turn them over for him to keep.
So I'm gonna say granted, but what I'm gonna add under rules of evidence and procedure. So I'll add that. Copies of any pin packet. I think that's the same.
Right, Judge.
And the concern we have particularly on this one is unstapling the pen packet, decertifying it, and efforts to copy it.
We'll put it right back.
So I'm gonna put under there under rules of evidence and procedure, because that covers the fact that they can't decertify it. All right, number 19.
We are not agreed, Judge.
All right, stay.
We're just saying it's the same as number 17. It's just the TCIC and CIC that we're concerned.
Okay. I'm gonna do, under rules of evidence and procedure. 20,
We are agreed.
21,
We're not agreed.
state,
Again, this is not within the state's possession, so.
all right, so I'm just gonna say, in state's possession.
Okay, and we just had concerns, Judge, that, you know, when they're getting ready for trial with the interviewer and she mentioned someone that wasn't previously listed in a police report, that the state would go ahead and tell us, you know, hey, by the way, this person's not listed in a police report or anywhere, but in our conversations with her, she did tell us that they may have relevant information.
Okay, and number 22, is that the same thing?
Yes, Judge.
All right, in state's possession. All right, what's next?
The next one's the election to jury for punishment, Judge.
I don't have that.
It's just you're just doing your election punishment.
Right.
Okay,
Yes.
so there's no.
Yes, okay. And who is your client if you were found guilty? Who's he going to punish?
Jury.
Okay. All right, just make sure that the clerk has that.
Yes, Your Honor.
All right, so what's the next one?
The motion to discover state's expert witnesses, and they've complied, Judge. They've tendered those already.
Okay. So I'll just grant that.
And Judge, on that, there's just one concern, is that the motion asks for stuff that's outside of 702, 703, and 3914B, so.
All right, then what I will do is then on it, instead of writing granted or denied, I'll say that you said that the state is in compliance. Is everyone okay with that?
That's fine, Your Honor.
State in compliance. Sure. All right, the next one.
We have the 612 and 615 motion, Judge. And I think
Yes.
we're agreed on that one. Is that right, Michael? That's what I have.
Which one is it?
The production of 612 and 615. Yeah, that one.
Okay. Oh, yes, Judge.
You're in agreement to vote?
Yes.
All right, they're asking for a date.
I take for,
They say the state is ordered to produce to the defense on or about. So what date are,
under Rule 612, day of trial, right?
Right, that's my understanding, Judge. Is upon cross-examination.
and when is our trial?
It's July 19th.
Let's see, is that a Monday or Tuesday?
I am not sure on that.
Oh, that's a Tuesday. All right, so, all right, we'll come back on, then I'll say on July. Well, we don't start testimony until the 20th. So I'll put July 20th. Okay. Okay, so you guys are actually going to show an impact court on the 18th.
Okay.
All right, and make sure you give them a reset form for the 18th. And then what I'll do then, I don't know if on the 18th you all immediately go to jury trial or not. So I can put on here the 18th or the 19th.
I just, so if for some reason it gets continued, can we just, upon cross-examination?
I think that's what the rule states, Judge, is under
Okay.
612 and 615. It's upon cross-examination. And so we would just ask, Judge, that, if they do tender, documents to us, we just be allowed a recess of maybe 10, 15 minutes just to review them.
Okay. So I'll put in each line then cross-examination.
Okay.
And then the state is ordered to have its witnesses bring the court any and all materials used to refresh memory while testifying or before testifying.
We'll ask if they have any other notes in the past to bring it.
Okay. And then the state is ordered to not comment in any way on the fact that the defendant has invoked any portion of Rule 612.
I guess we won't tell them whether we're providing it pursuant to an order of the court in Rule 612, Judge.
Okay. And then, all right.
We just want to look favorably upon them. That's what it is.
Okay. Next one.
It's defendant's motion limiting number 3, Judge.
All right. What is this about?
The ones that we just, if we can, the ones we don't agree on.
Yes.
Like number 4.
Wait, so you agree to one, right?
Yes, 1, 2, 3.
Okay, let me just write agreed. And number 3 is agreed.
Yes,
Okay, 4.
not agreed. Part of this includes,
All right, state to approach.
yes,
That's fine.
we're in agreement all the way up to number,
22, right?
we have a disagreement on 22.
All right, let me write this in. All right, 22.
We're not agreed, Judge.
Okay, so what are you asking?
Well, we're asking that the state not reference any of those documents. I guess their admissibility. The fact that, we would have shown you the police report, but it's not admissible.
Well, I mean, in the charge instructions, the court says that exhibits may have been marked, such as police reports and blah, 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 but they're not admissible.
Okay.
So I'm
It's
trying
also
to figure out.
presupposing that I know what the court's gonna rule on the admissibility of evidence.
All right, I'm just gonna say approach. 23,
We're agreed on 23.
24,
We are not agreed.
any statement attributable. All right, that's like a motion to suppress hearing.
Yeah.
So hopefully you all will have that. I'm just gonna do approach. But
If they would check. It's just, I can't, anything that's attributable, it doesn't seem like we need to have a hearing unless they ask for a hearing specifically, once we're trying to get into.
yes. 25,
We're agreed, and we're agreed on 26, Judge.
oh my gosh. I'm gonna say C, internal rulings. All right, which is the next one?
It's the Brady motion for criminal records of state's witnesses, which I think we just talked about, Judge. In the motion eliminating.
It's again, I always have concerns with CCIC and CIC. It will produce, we will
Make them available.
allow it for inspection, just not production.
Fine, Your Honor.
Okay. All right, and then you want it prior to cross-examination?
He'll make it available for inspection, so.
Yeah, I mean, it's already in the file.
Right, Judge.
Okay. So,
I don't think he's trying to play hide the ball.
all right, so I'm assuming then that the state has complied with this?
Yes, Judge.
All right, then I'll just put state in compliance. All right, list of witnesses.
They've provided, Judge, the only thing we would ask is that if something were to change, they would just update their list and provide it to us.
All right.
But
I'll
as of
put
now, they
state
comply.
in compliance. All right, next.
It's a discovery, I guess, request, Judge, on, it was filed on October 2nd, 2019. They've already complied, Judge.
All right, which disclosure of facts of data? Is that the one you're on?
No, Judge, mine just looks like a request to the district attorney's office. It doesn't look like an actual.
Okay.
These aren't motions,
Right.
so there's no order.
Yeah,
Okay, all
just a
right,
request.
Okay.
So I think that completes everything. This is what I know.
all right, thanks.
Am I missing?
I think this is
Well,
what
I
you-
do have this one. It says defendant's motion to require disclosure of facts of data underlying expert's opinion.
Okay, I apologize, Judge. That one must have missed my folder. Judge, I guess if they're gonna call any sort of, well, any sort of sane nurse or anything along those lines, we would ask if they provide any sort of data that she's relying her opinion off of, based on.
And I think that'll just be her interview.
And so, Judge, a lot of this is outside of what's particularly mentioned in 3914B. And so we're going to comply with 3914B as required, but I think to expand our obligations is unnecessary, and we'd object to any expansion of 3914B.
Okay, you'll need to take that up. I'm just gonna say, according to the rules of evidence and procedure.
Okay.
Is everyone in agreement with that?
Yes, Judge.
That's fine, Your Honor.
Now we got to get Brandon to put all of that on the record.
Go back.
She said she really wanted to go back. to the
All right, well, you guys have all the motions and I filled them out.
Thank you, Your Honor.
Thank you, Judge.
So if you guys can, we'll see you back on July 18th.
And we're heading to impact report that day?
Yes.
Okay. We need to sign a reset, Your Honor?
Oh,
Or
yes, and then you're excused.
just- Okay, thank you, Judge.
Amazing how we changed.
All right, who's here on Alvin Kirby? Oh, I'm so sorry, Caroline, just so you know.
Connor Morris, church clerk for the defendant. I thought I need your services, but we've reached an agreement,
Okay,
so we're okay with it.
all right, thank you. They've reached the agreement. Jose Ramirez? Jose Ramirez? What is happening with Jose Ramirez?
The state's gonna ask for.
We can have 30 days. We actually have a victim, I believe they may come in today or tomorrow to talk to us about, it's an SBI case, so I wouldn't.
It's a first set.
Extend their injuries and talk to them about restitution and offers and stuff.
Okay, so is your client in custody or on bond?
He's on bond. He's
All
here.
right, where's Mr. Jose Ramirez? Come forward, please.
He's earlier. He's here.
All right, bring him in. And Norma, can I get a 30-day reset on Jose Ramirez, please? All right. And Brenda, did you see what page Mr. Ramirez is on? All right, thanks.
Sorry.
All right, Mr. Ramirez?
You want to come up, John?
Yes. Mr. Ramirez, we're going to be back on your case on July 25th. Just get a reset form from Ms. Ferguson.
Okay.
You're welcome. David Signs. Yes. Are you ready to proceed on Mr. Signs? All right. Mr. Signs, come on up. What is happening in this case?
We're gonna alternate amend judges and plead true to condition number 5.
Okay. Brenda, are you ready?
I'm ready.
Court is calling 2020 CR 11967, State of Texas versus David Galvan Signs. Can I have parties announced for the record for the state,
For Eastbar,
for the defense?
Rolando Arguelles.
And are you Mr. Signs?
Yes, ma'am.
Mr. Signs, I'm showing you what's entitled motion to enter adjudication of guilty and revoke community supervision. Did you review that document with your attorney? Did you understand it? Are you the same David Galvan Signs who is placed on deferred adjudication for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on January 19, 2021 for a period of 2 years? Is that you?
Yes, ma'am.
State?
yes, Judge, violated condition number 5 in Bexar County, Texas. The defendant, David Galvan Signs, did then and there fail to report to the supervision officer as directed for the months of March and April of 2021 in violation of condition number 5.
How do you plead to that? True or not true? State?
And Judge, we're gonna waive all other violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find number 5 true, not grant you community supervision and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Staff, please. Is there an agreement?
Yes, Judge, we're asking that you alter and amend to add a TAP evaluation. The defendant was originally ordered to do a drug court evaluation or referral. He refused to do that program, so he was not accepted. And you had ordered, if he was rejected, to send him to IOP. So we're asking that you now send him to IOP.
We are in agreement to do the outpatient. Your Honor, I talked to probation and they can do a top evaluation if he's released in a week. And I told him,
Why are we doing a TAP evaluation and wasting resources when he informed felony drug court that he had no drug problem
well, none of
and
the,
that he did not want to sign? That's the report the court received.
correct, Your Honor, none of the violations are alleging any drug violations at this.
So he doesn't have a drug problem. So I should send him out into the world with no drug treatment because he's saying that he doesn't have a drug problem. And if he ends up testing positive, that's on him.
Yes, Judge.
That's basically where we are.
But my client is agreeing to do an outpatient treatment for the court.
Here's the thing, if you don't have a drug problem, then there are limited resources, and those limited resources need to be for people who have drug problems. But what I can tell you is, I will send him out into the free world with no drug treatment because he told felony drug court that he didn't have a drug problem. And if he ends up testing positive for anything, be it alcohol, be it marijuana, be it meth, be it cocaine, be it heroin, whatever it may be, a motion to revoke will be filed.
Yes, Your Honor.
Yes.
Yes. So do you have a drug problem?
Speak up.
Nope. You need to say yes or no. No shaking.
No.
All right. So what I'm going to do is I'm going to deny the motion, alter and amend conditions to include the UA hotline until further notice. All other conditions are to remain.
Thank you, Your Honor.
And there's going to be field visits, random, 2 times per month for 6 months.
Yes, Your Honor.
And I've already noted on the document sheet, defendant says he does not have a drug problem.
Thank you, Your Honor.
All right,
Maybe be excused.
well, he can't.
Yeah.
But,
He'll walk out right with me.
yeah. Probation will go over conditions with him.
Thank you, Your Honor.
David Rosas, and where's David Rosas?
He's in federal custody with not bothered.
Okay.
That's why I wanted to check with the court, see how you wanted to do it.
Ah. So, state, Mr. Rosas is in federal custody. What is he in federal custody for?
I can find out.
All right, because I'm wondering, what are we looking at and whether or not the state is going to proceed on their case? Because we've been doing this federal custody thing since October.
He's been in the whole time.
Yeah, I know. Yeah. No, that's why I say,
Okay.
October 5th, defendant retained, federal case pending. November 2nd, federal custody. December 3rd, federal custody. January 11th, federal custody. February 17th.
You asked Neil, because I think he has a sentencing date, if I remember recalling correctly, he has a sentencing date coming up. And then we had a potential resolution.
He used to be sentenced on May 19th, but we passed that. So what I have is recall May 23rd, defendant to be sentenced on May 19th.
Okay.
And then May 23rd, state to confer defendant sentence in federal court to 21 months.
I think I talked to, if my recollection is correct, I talked to Neil about this and I thought we had a potential resolution to happen. Yeah, we can come over and.
All right.
So we didn't have him brought over?
Yeah, I'm talking to Neil first.
All right, Ms. Ferguson, can I have a 3-week reset on Mr. Rosas, please?
I'll try to get a hold of Neil in between.
All
now
right,
and
thank
then.
you. All right, yes. So here's the thing. Ms. Ferguson has told me that federal, they don't want to do Zoom. Is that correct, Ms. Ferguson? Federal, do they do Zoom or no? No, they do not. They will not do Zoom.
Okay.
So if somebody can call one of the judges over there and see if they can make that happen, that would be great.
Okay.
So we'll be back on the 18th and let Ms. Get a reset form from Ms. Ferguson.
Good.
Who's here on Joe Jimenez? Where's Mr. Jimenez?
He's the same excuse Paul just did.
Yeah. Is he in federal custody?
He is, Judge. I checked with the state. I know he's in Karnes County. I know it's a drug case. I have not talked to his federal attorney as of yet. The mom was giving me that number, and the state checked their emails and said, yeah, he is in federal custody. I'm not sure what it is.
All right, who's the federal attorney for him?
I think the mom's gonna get that stuff from me this week.
All right. All right, Ms. Ferguson, can I have a 30-day reset on Joe Jimenez, please? All right, so we're gonna come back on the 26th and see where we are with the federal custody. Ms. Ferguson will give you a reset form.
Okay, thank you. And may I ask the court on a off-docket matter?
Yes.
Mr. Curry, not Curry, for some reason was set yesterday. He showed up. No, a lot of my cases were like that. And that setting was going to be for just the evidence. And then he said on July 25th for trial. I just want to know if that 25th date is still going to be our trial date, if we need to come in before that.
Let me see. Okay, the 25th is, we actually have jury trial on Tuesday, so the 25th will be all for you to show up to see if there's anything else that's needed.
Okay.
But so it will be the 26th is your actual trial date, but you'll need to be here on the 25th.
July, okay. Thank you,
Yes.
Judge.
All right, thank you. I am calling in order of appearance.
Carolyn.
Eric Arocha? Yes, what is happening with Eric Arocha? And where's Eric Arocha? Person in the back, I know it's cool and it's hip, but you need to take those shades off. Yes. What is happening on Arocha? Are you?
We have a agreement, Judge.
All right. Brenda, you ready? All right, the court is calling 2020 CR 10446, State of Texas versus Eric Jeffrey Arocha. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Juan Aguilera.
And are you Mr. Arocha?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Are you the same Eric Jeffrey Arocha who was placed on deferred adjudication in 2020 CR 10446 for the offense of possession of a controlled substance, Felony Group 1, less than 1 gram, on January 26, 2021 for 2 years?
Yes, sir.
State?
Yes, Judge, violated condition number 2, on or about the 19th day of April 2021 in Bexar County, Texas. The defendant, Eric Jeffrey Arocha, did then and there illegally use a substance, namely marijuana, in violation of condition number 2.
How do you plead to that, true or not true?
True. Yes, Your Honor.
Violated condition number 2, on or about the 16th day of November 2021 in Bexar County, Texas. The defendant, Eric Jeffrey Arocha, did then and there illegally use a substance, namely marijuana, in violation of condition number 2.
How do you plead to that, true or not true?
True, Your Honor.
And violated condition number 5. In Bexar County, Texas, the defendant, Eric Jeffrey Arocha, did then and there fail to report to the supervision officer as directed for the months of July, September, December, and January 2022 in violation of condition number 5.
How do you plead to that, true or not true?
True, Your Honor.
We're going to waive all other violations.
Any objections to the state waivers? Mr. Arocha, did you understand by pleading true to violations 2, 2, and 5, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 2, 2, and 5?
Yes, Your Honor.
Court will find 2, 2, and 5 true. Is there an agreement?
Yes, Judge, we're asking that you deny the MTR and alter and amend to add a referral to felony drug court.
All right, Mr. Arocha, is that what you're asking the court to do?
Please, Your Honor. I
All
would
right.
truly be grateful.
All right, do you have a drug problem?
No, ma'am, Your Honor.
Then you know the key to felony drug court is it's felony drug court, which means you have a drug problem.
Okay.
It's not felony, I don't have a
Okay, Your
drug
Honor.
problem court. You understand?
Yes, yes, Your Honor. I understand. I'm sorry.
So, do you have a drug
Yes,
problem?
Your Honor. Yes, ma'am.
And if you drug tested today, what are the results going to be?
THC positive.
He was tested, the drug tested
I
this
was
morning.
testing. Yes, Your Honor.
Okay,
He
thank
admitted
you.
he had been got released May the 20th and he smoked on that day. So we knew that he was going to come positive.
I apologize.
All right. No, I mean, it's not an apology. I appreciate your apology, but you need to be apologizing to your body.
Absolutely.
So, do you have any children?
I have one, yes.
Yeah, I see where I asked for parenting classes. Is that child in your custody?
Yes, ma'am. I understand.
And how old is your child?
He's 3.5, gonna be 4 in November.
Here's the thing, you need to stop his foolishness. Do you understand?
Yes, yes, ma'am.
So you're gonna go over to felony drug court. I'm gonna deny the motion to alternate amendment conditions to include felony drug court. But you're gonna go over there, and you're gonna be the best participant. If you're not doing it for yourself, you're gonna be doing it for your child. You understand?
Yes, ma'am. Your Honor.
Because there's not a single child out there who wants to say, oh, that's my father, the person who keeps using drugs. You understand?
You're absolutely 100% correct. Yes, ma'am.
All right, good luck to
Judge.
you.
We could address something. He's currently on GPS monitor and you were good enough to allow him. He kind of acts as a caretaker for both his brother, who unfortunately in April was shot. And so there was a wound, open wound in the front, open wound in the back treatment. But he also, his his father is blind veteran, Vietnam veteran, so was taking him to his appointments. If we could, maybe you could also allow him to go and find a job so he can start helping out the family. He lives with his parents, so we could help.
Are you smoking marijuana at your parents' house? All right, are you being paid to take care of?
No, ma'am, Your Honor, as of now, no, ma'am. We're looking into that.
Oh, no. Here's the thing. I don't allow people to be home healthcare providers when they're on felony probation.
Okay,
So if they're looking into that, it'll be for somebody else to take care of him, not for you to take care of him and receive payment. You understand?
yes, ma'am.
And Judge, I believe Social Security Administration does not allow people on either deferred or probation to serve as home health providers.
I appreciate that, but do you know, I've had some people who are home health care providers, and I'm just like, no. All right, so I'm gonna keep him on GPS until he's accepted in the felony drug court. But he is allowed to attend whatever medical appointments and to seek employment. Does anyone have a problem with him seeking employment? Okay. So he's gonna be allowed to attend all medical appointments for himself and family members. With proof of appointments. And look for employment. And the hours for him to look for employment, he needs to be back in the home by no later than 7 p.m. So there's a 7 p.m. curfew.
Thank you, Your Honor, so much.
All right, you're welcome to do better, okay?
Absolutely.
That'd be a excuse, Your Honor.
Yes.
Thank you.
Thank you for your time.
You're welcome. Jesse Salinas. Jesse Salinas. Who's the attorney for Jesse Salinas?
He stepped out.
All right, just have a seat. And Caroline, this is this. Thanks. Isaiah Gonzalez.
Judge, I have that case.
Yes.
I
And where's
was
Mr.
about to-
Gonzalez?
He's in the witness room. We were just discussing the plea bargain. Your Honor.
Okay.
Yeah, we're just continuing to confer on that.
All right, thank you.
I apologize. The reason why I got up on your desk is because he was telling me trial. Now he's talking plea bargain, so I.
Okay. Oh, no problem. Kenneth Leach. Kent Leach.
Good morning, Judge.
Hello.
Judge, we're here just to confirm the medicals
Yes.
from the state. We do have those medicals.
Okay. All right. Just a moment. All right, so do you have all of the discovery now?
I do, Your Honor.
And was an offer tender?
We're still negotiating. He wants to review that with the alleged witness in the case. So we're going to be conferring on that.
All right, Ms. Ferguson, on Leach, can I have a 3-week reset, please? All right, we'll be back on July 19th, and that's for the state to make an offer.
Yes,
And then after that, I'll give you a plea deadline date, Mr. Leach.
Yes, ma'am.
All right, thank you.
Thank you, Judge. Thank you.
You're welcome. Patricia Elder. Is the attorney here for Patricia Elder? Brenda, you ready? Court is calling 2022 CR 2345, State of Texas versus Patricia Elder. Can I have parties announced for the record for the state?
Brittany Starks.
Defense,
Andres Candy for the defense.
and are you Miss Elder?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
To the best of my knowledge, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Elder, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I think this is the one we're proceeding on count two.
Yes.
Waiving count one.
And also, is that correct? You're proceeding on count?
Proceeding on count, on straight possession,
Okay,
waiving. with
so
intent.
count two.
Proceeding on count two, waiving count one.
Any objection?
No objection from the defense. So long as we're proceeding on straight possession.
Yes, and that is count two. All right, Ms. Elder, I'm going to show you what's entitled court admonishments, defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on count two, which is possession of a controlled substance penalty group 1 gram or 4 grams? It's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Ms. Elder, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Oh, yes.
Are you a U.S. citizen?
Oh, yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, the state is proceeding on count two. Punishment is to be assessed at 7 years in the prison. There's a $500 fine. State recommends community supervision. They will take in consideration grand jury number 757-981, and there's $60 restitution for testing. Did you understand that to be the plea bargaining agreement?
Yes, Your Honor.
Defense, is that the plea bargaining agreement?
It is, Your Honor.
State, is that the plea bargaining agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not been, Your Honor.
Oh, I think you're a client. Did your client sign?
Yes, she did.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 4 years, to be a TAP evaluation, 100 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count two in the indictment, how do you plead? Guilty, not guilty, or no contest?
I plead guilty, Your Honor.
State any evidence.
Yes, Judge. State office, state exhibit 1 and all attachments.
No objections, Your Honor.
Ms. Elder, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. And the court will find you guilty of count 2. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
No, Your Honor, we would just ask that the court follow the agreement. This elder has been as diligent as she can on her pretrial supervision. She has taken care of everything else that is outstanding with the county, and to include a previous case that she is currently on probation for, that we would ask the court to allow run concurrent with this case. And that is cause number, County Court Cause 614127. She has, since being on, I believe, felony pretrial supervision, she has made an effort to constantly be in contact with her pretrial supervisor. She CCs us on all those contact emails, has been very proactive in attempting to get help from outside sources, and she has done that. Has completed the sober living, lifetime recovery. So she has completed that process, and she has also attended AANA. Is still currently, and I believe is required to as part of the misdemeanor supervision. She is well on her way to the road to recovery, but as everybody knows, it is not a one battle and done. It is a daily battle, and she is fighting that fight every day, Your Honor, and just wishes that the court would allow her to do that as someone who is on community supervision as opposed to being incarcerated.
All right, so are you in a sober living home?
No, ma'am. I live at home with my husband of 23 years. I've been completely clean and sober since September 14th last year. And I do attend a Zoom meeting called Nuts for AA / NA. They also talk about nicotine too. It's a good group. And I completed a lifetime chemical dependency Zoom program. Also, my counselor, I'm still in contact with her, Maria, and she's been working with me on some journaling. And so right now I'm working on some journaling programs, self-talk, so on and so forth. I've completed like 5 of them, but that's an ongoing thing too, because there's never enough you can learn about yourself.
That's true. Are you employed?
No, ma'am, retired, and I babysit my grandbabies for my daughter during the day, summertime.
She does have passive income through.
Oh, yes, rentals.
A rental property.
I rent
so
my.
She does have
yeah.
the ability to pay these. The state has recommended a fairly low fine, and we're appreciative of that.
Yes.
Because her income is fixed. And if the court would like, I would like to approach and tender the lifetime recovery certificate.
All right, this is what the court is going to do. The court is going to sentence you to 7 years in prison, suspended and probated for 4 years. $500 fine probated, taking consideration grand jury number 757981. $60 restitution to laboratory for testing. This run concurrent with 614127. 100 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived.
Okay.
There's to be no employment as a home health care provider with minors. You continue with your sober meetings.
I'm sorry.
Yeah, I don't understand. She's not to be.
She's not to seek any employment with minors. So nobody, she's not hired as a babysitter.
Oh, no, I'm not hired. It's
No.
okay. Yeah, I'm doing my daughter.
She's babysitting her own grandchild, but she's not doing it for money. I was just, she's not to run a daycare is what the court is saying, right?
There's not to be no exchanging of money.
Of money.
Oh, no.
Oh, okay.
With any minors.
Right, she's not doing this for profit. She's doing this because.
So there's to be no employment as a home health care provider with minors. you to continue with your sober meetings. There's to be regular reporting by Zoom or in person. There's to be regular UAs. And I'm gonna want field visits 2 times per month, random. Is there anything else that she needs? Is there anything else you need from the court to be successful?
No, other than I noticed there's my address is not correct. on there.
The address on the indictment isn't an accurate address. I don't know if
Just like probation.
Okay, yeah,
we'll update probation with the accurate information.
yeah, other than that, no.
All right, I'm gonna show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did, Your
All
Honor.
right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
If you have a question over what a weapon or ammunition is, you'll need to speak with your attorney.
I don't
And
need-
stay on the right path,
Yes, ma'am.
because I normally don't allow people who are on felony probation to have unsupervised contact with minors, because I have concerns. So you need to stay on the right path. You understand?
Yes, ma'am. Thank you
All right.
very much.
Thank you. Probation will go over conditions with you.
Okay, thank you, ma'am.
You're welcome. Who is on? Vallejo? Vallejo? The double L's get me every time. Good morning. What is happening with this case? And where's
Ryan had just.
Julia Vallejo?
Right here, Your Honor.
Yes.
Hello.
We're waiting on Ryan to get in. He just stepped out. I think he went to the restroom.
All right, so where are
He's
we?
on crutches.
Oh, yeah, I know he's on crutches. Oh, so where are we on this case?
Judge, this matter is pending in probate because the burglary is involved in the probate. And we're trying to get that resolved. It shouldn't take more than maybe 3 to 4 weeks to get that closed out. And then we'll be ready to close this out. But anything that happens in this case will be detrimental in the probate case because the parties are all involved in the probate.
All right, Ms. Ferguson, can I have a 30-day reset on 26? So we'll come back on July 26. Just get a reset form from Ms. Ferguson.
Yes, ma'am. Thank you.
Thank you.
Yeah, for a chance.
We go in order of appearance. Is there something you needed to approach?
No, just,
Yes,
just checking in because I had a lot of courts this morning, so.
no problem. Thank you. Aaron McDonald.
Judge.
Hello.
I'm here on behalf of Judge Sawyers. Mr. McDonald is not here right now. There was a miscommunication. He has a plea. We thought he had a plea via Zoom at 1:30. He's on his way here and he will be here this afternoon to take the plea in your court instead.
All right, thank you.
Thank you.
Jesse Salinas. Jesse Salinas. Mr. Salinas, is your attorney here? All right. Just have a seat. Alvin. Oh, they're coming back this afternoon. Alvin Kirby. Court is calling 2021 CR 6504, State of Texas versus Alvin Kirby. Can I have parties announced for the record for the state? For the defense?
We're ready.
And defense, if you could move that way, your client in the center. Are you Mr. Kirby?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Kirby, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Kirby, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft, 2,500 to 30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does. Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I'm sorry, Your Honor, I didn't hear.
Do you believe that he was
Yes, Your Honor.
competent and legally sane at the time of the offense?
Yes, Your Honor.
Mr. Kirby, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $500 fine. State recommends deferred adjudication. Did you understand that to be the plea bargain
Yes,
agreement?
ma'am.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Sorry, Your Honor.
Have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, state offer states exhibit 1 in all attachments.
Any objections?
No, Your Honor.
Mr. Kirby, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I think he's learned his lesson, Your Honor. if anything.
You understand that you put your wife / fiance in a precarious position. Do you understand that?
Yes, Your Honor.
So if you love someone and that person is the mother of your children or either the father of your children, you shouldn't be doing things that will hurt them or detrimentally impact their lives. You understand?
Yes, ma'am.
And because of what you've done, she now has a crime of moral turpitude stamped. Even though it's deferred, it's still stamped on a record. You understand? So are you employed?
No, ma'am.
Why not?
I do a disability. I got injured. I got shot in the back of the head.
Mhm.
I got hit by a car that flew over his ribs.
So do you receive SSI?
Yes.
All right. This is what the court is going to do. $500 fine probated, 2 years deferred adjudication, 120 hours community service restitution. 40 of those hours will be deducted if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be deducted. I'm going to want parenting classes. Upon completion of the parenting classes, the remaining of the community service hours will be waived. There's to be regular reporting by Zoom or in person. There's to be no employment as a home health care provider or with minors. There's to be field visits 2 times per month, random and state. I remember the other case, his wife had restitution.
Yes, Judge, we could only link the restitution to her.
Okay. All right, and there's going to be regular UAs. Probation, is there anything else that he needs?
No, Your Honor.
Is there anything else you need from the court in order to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Okay. Did you review that document with your attorney? Did you understand it and did you sign it? Did you review that document with your attorney? Did you understand it and did you sign it?
Oh, yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Caleb Coleman. Caleb Coleman. Where's your attorney? All right, you need to come forward. Why are you late? Come forward. That's no excuse. You're not to be late for court. You understand? When you're late for court, guess what ends up happening? You throw off everybody's schedule. You throw off your attorney's schedule, because then your attorney is thinking, I'm going to hit this court first, then I'm going to go there, and they can't do that because you're late. You understand? All right, what is happening with Mr. Lee? I see that today, let me see, all for tenant today is the plea deadline day.
Yes, Judge, we're gonna ask for a extension on that. We did find out when we reviewed the file today that there was some medical records in there that we have not yet seen. So those are being downloaded, so we can review those.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Coleman, please? All right, we're gonna come back on July 26th, and your plea deadline date will be July 26th. Let's get a reset form from Ms. Ferguson.
Okay, thank you, Ms. Ward.
You're welcome. D'Angelo Robinson.
Morning, Judge.
Good morning. All right, where's your client?
Stand up.
Why is everybody being afraid to come forward? Mr. Robinson, come forward. Bring up, people are moving so slow. They definitely will not be on a track team. So what is happening with your case?
I have filed some discovery requests. The state has made an effort to fulfill those requests. They did say that they, one of the things that I requested was fingerprint analysis report. They said that there's not one, but that they can provide the fingerprints. So, you know, we'd like that. We'd like more than that, but we'll take that. And then they were going to look at another issue. I asked about a photo array. There were 2 6-packs in one of the cases, the ag robbery case. There's 2 ag robberies, but they were related.
Is this scheduled for jury trial today?
Okay,
Okay, thank you.
I don't know if we had it.
I think Marcus and everybody is in a complete state of shock. I have these questions. All right. Ms. Ferguson, can I have a 3-week reset on Mr. Robinson? And it's going to be to handle whatever discovery issues they are, and you all need to confer off docket on the motion, and then what you can't agree on, I'll make a ruling. All right, we'll be back on July 19th. Get a reset form from Ms. Ferguson.
Thank you, Judge.
You're welcome. All right, Carmelo Figueroa. All right, the court is calling 2021 CR 8903 and 2021 CR 8904, State of Texas versus Carmelo Figueroa. Can I have party A's announced for the record for the state?
Brady Sparks.
For the defense?
Catherine Valenzuela.
All right, and are you Mr. Figueroa?
Yes, Your Honor.
All right, in each of these cause numbers, your counsel has filed a motion for continuance. State, do you have any objections to the motion?
No, Judge.
All right, Mr. Figueroa, do you understand the reason for the motion for continuance?
Yes, Your Honor.
Do you have any objection to the motion for
No, Your
continuance
Honor.
from your counsel? All right, Ms. Valenzuela, your motion for continuance will be granted. When will you be available?
I will be available after the Monday, like, I think it's the 11th or 12th of July.
All right, Ms. Ferguson, can I get a jury trial date for Figueroa? And she says after the 11th. All right, we'll be back on the 19th. Let's get a reset form from Ms. Ferguson and we'll see you then.
Thank you, Your Honor.
All right, I hope your husband is better.
So do I.
Yeah.
You got one. Thank you.
They're gonna have to come back at 1:30. Jesse Salinas. All right, Mr. Salinas, we'll see you back at 1:30. Isaiah Gonzalez.
Yes, Your Honor.
Yes.
The request is that he's ready to accept the plea bargain. There are some preparations he has to do. For example, he's on bond. He just got into an apartment. He's got to let the landlord know. He's got to put his clothes with a friend or in storage. So
All
he's
right,
asking
well,
if he can plea today and then, I'm sorry.
Yes, we can plead today and then state, if you're doing the paperwork for the plea on Mr. Gonzalez, of course, when the court allows people to plea and they come back on a different day, I require that they know that the full range of punishment will be available if they don't appear. All right, so if we'll do the paperwork and we'll be back at 1:30 to do that plea.
Okay, Judge.
Thank you. Dorina Garcia.
President Council, Your Honor.
Yes, what is happening with this case?
We have also a co-defendant in the case earlier that was recent as well. Brian was on the case. We agreed that we're waiting for another matter to settle and it's really close, the 30-day reset, the state agreed with me on.
All right.
But Brian's not here right now, but
No, I understand. Ms. Ferguson, can I have a 30-day reset on Dorina Garcia?
July 26th.
sounds good.
All right, after that, the court is not going to
Your
give
Honor,
any further extensions.
And I really hate to bring this up. July 26th, my 20th anniversary is July 21st. I'm going to be in California.
Okay.
Do we
Do
do
they want
something?
you there though?
Huh?
Sometimes maybe they want people. Sometimes the best
My
trips
wife's-
are when you're away from people.
20 years, Your Honor. We're doing great.
Okay, does she want you there?
Of course. She's my orchid, Judge.
Okay.
I've heard it. I know.
I like that. All right, Ms. Ferguson, I have another date other than 26. I don't want to be the cause of his
The
marriage
week
breaking
after
down.
August. That's fine. That's fine. Yeah,
All
we-
right,
we
we'll
should be
see you
back on
August
30th.
1st.
Thank you, Your Honor.
You're welcome. Just get a reset form.
Yeah, will do.
Caleb Coleman. Caleb Coleman. All right, 1:30. I think I did. Mhm. Okay, all right, thanks. Joel Aguilar. Joel Aguilar. Yes, what is happening?
It's a plea.
All right, thank you.
Lesser included offense.
And the last case the court is calling is Jason Brown. After that, we're taking our break. Court is calling 2022 CR 1780, State of Texas versus Joel Aguilar. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Ron Ross will respond. For the defense.
And are you Joel Aguilar?
Yes, sir.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled, I'm sorry, defense. Do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We're proceeding on the lesser included offense of assault, bodily injury, family household.
Any objection?
No objections, Judge.
Mr. Aguilar, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Your attorney, did you understand it? And did you sign it in all the appropriate places?
Correct.
That's either yes or no.
Yes, sir. Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family household as a class A misdemeanor? The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have I'm sorry?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes. I understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? You need to speak up.
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on the less included offense of assault, bodily injury, family household. Punishment is to be assessed at 187 days in the Bexar County Jail. Credit for any time served. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Sure.
Not
Yes, I
correct.
understand.
Yes, sir.
Yes, I understand.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, I understand.
Defense is at the plea bargain agreement.
Judge, I think we've agreed there'd be no harmful contact with the father.
That is correct. I'm okay with that.
All right. Then with that being said, do you understand that to be the entirety of the plea bargain agreement?
Yes, yes, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Could you all initial that, please? Did you understand by assigning that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense of assault, bodily injury, family household, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No problem.
State any evidence.
State offers State's Exhibit 1 that's attachment to the evidence.
Any objections?
No objections, Judge.
Mr. Aguilar, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of assault, bodily injury, family, household. Are you proceeding with sentencing?
We are, Judge.
Court will follow your agreement, sentence you to 187 days in the Bexar County Jail. You get credit for any time served. There's an affirmative finding of family violence, and there's to be no harmful or injurious contact with the complainant. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Mr. Aguilar, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Also, because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I
If
understand.
it's a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, good luck to you. We can go off the record. You only get one father in this life, and you need to treat
Sure,
them
sure.
well. Understand?
Yes.
And if you don't want to treat them well, then don't live in their household. Get your own house.
Yes.
All right, good luck to you. Who's here on Jason Brown?
I am Judge.
Yes, what is happening with Mr. Brown? And Where's Mr. Brown? Mr. Brown, come
Yeah,
up.
he's right here, Judge. Can I bring him up?
Yes.
Judge, this is a 2019 case. I'm relatively new to it. In June of 2019, at the time of this, Mr. Brown's arrest with a co-defendant, there was a fingerprint examination done on the weapon that was found underneath the seat where Mr. Brown was located. I think Marcus checked, there's been no return of any sort of fingerprint examination. Obviously, the existence or lack thereof of any sort of fingerprints is going to be vital to my client's defense on affirmative linkage. So I'd ask the court for time so the state can talk to the detective and see what happened with that report.
When will you have information on this?
Judge, I can find out this week.
All right, Ms. Fergus, can I have a 3-week reset on Jason Brown? Then after that, it's going to be a jury trial. All right, we're going to come back on July 19th.
Okay, thank you, Judge.
Just get a reset form for Ms. Ferguson.
Will do.
Thank you, Your Honor.
You're welcome. And with that, the court is in recess. Brenda, you're excused.
Okay, thank you.